Audio will be participant cameras and audio will be turned off during the presentation. If you need assistance at any time today, please type your comments into the chat box, and you may also type your questions for the speakers into the Q&A box. A copy of the presentation of the slides will be shared in the chat box soon. And now it is my pleasure to introduce David Cessante.
Thanks, Amy. Thank you, everyone, for joining us today. We've got you for an hour here, and I'll try to do my best to honor that time frame so you can get back to whatever you have going on today. Today's presentation is called Discrimination in the Workplace and How to Protect Against Discrimination Claims. What we're going to talk about are the laws that cover discrimination, what an employee has to do from a legal perspective to establish a claim of discrimination, what the employer's defenses are to a claim of discrimination, and probably most importantly for those of you who have joined today, what steps can an employer take to prevent an employee from successfully bringing a claim of discrimination. And as part of that discussion, we'll focus on how to properly document and manage employee performance issues, as many times the steps that you take up to the termination decision or the demotion or the suspension or whatever it is that's prompted the claim of discrimination will often dictate whether or not you're going to be successful when defending that claim, or whether the employee or former employee is going to be able to prevail in the context of a lawsuit or perhaps some type of an administrative charge with the EEOC or the Michigan Department of Civil Rights or whatever state agency the employee has filed with. As Amy mentioned, if you have any questions during the presentation, feel free to type your question into the chat box, and we'll certainly do our best to grab those questions as they pop up and address them in real time. So let's talk about the different types of discrimination claims. As you can see from this slide, there are several different laws that protect against discrimination. The first 5 bullet points here are all federal anti-discrimination laws, which means that they apply to employers throughout the country. And then, as we'll talk about at the end of this section, there are also in most states, not all, but definitely the vast majority of states also have their own anti-discrimination laws, which either supplement, add to, or create some additional responsibilities and conditions for employers. I'm only going to focus on the Michigan statute today, but just be mindful of the fact that if you have operations or offices in different states, it's highly likely that those states have their own anti-discrimination laws as well. So let's talk about each of these. The first one is Title VII, and Title VII applies to employers with 15 or more employees, and it protects employees and applicants from discrimination based on race, color, sex, religion, or national origin. For a period of time, there was some question about whether sexual orientation was covered by Title VII, and that's been conclusively decided that it does, in fact, protect sexual orientation as a form of sex discrimination based on stereotyping and other type of characteristics that we would typically associate with a particular gender. So sexual orientation is a subset of the gender or sex discrimination categories clearly protected. Before an individual can file a lawsuit under Title VII, he or she must first file a charge of discrimination with the EEOC, which is the federal agency that's responsible for administering the anti-discrimination laws. And that has to be filed within 180 or 300 days from the alleged discriminatory act. The difference will depend on whether or not the state that you're in has its own state equivalent to the EEOC. So for example, in Michigan, we have the Michigan Department of Civil Rights, which is the state equivalent to the EEOC. So in Michigan, the charge has to be filed within 300 days of the alleged discriminatory act. If you're in a state where there is not a state equivalent to the EEOC, then the charge has to be filed within 180 days. And again, most states are going to have some type of administrative agency that's similar to the EEOC. So that 300 days is the more prevalent of the two when it comes to the filing deadline. The ADEA, which is the Age Discrimination and Employment Act, this applies to employers with 20 or more employees, and it prohibits discrimination against employees or applicants based on age. The cutoff here is that you have to be 40 years old or older. So it's designed to protect against discrimination against quote unquote older workers as opposed to younger workers. And again, there must be an administrative charge filed with the EEOC or this or the state equivalent within the appropriate period of time. The Pregnancy Discrimination Act, as it suggests, prohibits discrimination on the basis of sex, but in particular, it prohibits employers from discriminating against employees because of pregnancy, but also due to childbirth or pregnancy-related conditions. So it's essentially a subset of sex discrimination, and it's largely the same as what would be covered under Title VII, but there is a special and specific act that's designed specifically to address pregnancy discrimination. Going on, we have the Equal Pay Act. The Equal Pay Act prohibits employers from discriminating on the basis of gender when it comes to paying wages. You can bring a pay-based discrimination lawsuit under Title VII if you believe, or if the employee believes that he or she's being paid a discriminatorily low wage based on any of those protected characteristics we talked about earlier. So that's available to employees under Title VII, but the EPA is a statute that applies specifically to gender, and it's a fairly prevalent statute in terms of employees filing claims under the statute, because we'll talk about the framework for Title VII here in a moment, which would apply to a pay discrimination claim under Title VII. But the appeal, if you will, to employees filing under the Equal Pay Act is if there is a differential in pay between, it's typically a female who files. If the female employee is being paid less than the male employee, then the burden shifts to the employer to prove that the wage differential is based on one of 4 affirmative defenses, which are set forth here on the screen, meaning that the employer has to prove that the reason the female is paid less than the male is because compensation was set based on the seniority system or a merit system or a system that measures earnings by quality or quantity, or the 4th factor, which is by far the most common, which is that the differential is based on any factor other than sex. And that typically relates to the geographic area where the employee might be located, where, you know, the wages may be higher in a particular area. So the female is paid less. It could be based on experience. It could be based on credentials. It could be based on tenure. There's a whole number of factors that you could look at. But the appeal here for the employee is that the employee just simply has to show that there was a difference in pay, meaning one employee was paid more than the other employee in the same job. And as long as that showing has been made, then the employer has the burden of proof to show that the pay differential is not based on gender. That's why it's a very appealing statute for plaintiffs to file under. Last but not least, under the federal scheme, we have the Americans with Disabilities Act, and this protects qualified individuals with a disability from discrimination. A disability is a physical or mental impairment that substantially limits an individual's major life activities. So physical or mental impairment, substantially limits, and major life activities are all terms of art. They're all defined. They've all been the subject of substantial amount of litigation over the years. And I could spend an hour just talking to you about claims under the ADA, but we're not going to do that deep of a dive today. The point here is just to say that obviously you can't discriminate against employees when it comes to disabilities, and that would include denying requests for reasonable accommodations. Those are claims based on actual disabilities, meaning that the individual has an actual disability, whether it be physical or mental. You should also be aware that the ADA provides for regarded as claims, and that is a situation where the employer regards the employee as having a physical or mental impairment that prevents the employee from doing his or her job, when in fact the employee either doesn't have the impairment that the employer believes him or her to have, or the employee does have the impairment, but it doesn't prevent the employee from doing his or her job. An example of this would be where an employee has cancer, let's say, for example, and because the employee is going through chemotherapy, the employer suggests to the employee, oh, you should take some time off. You shouldn't be working. This is dangerous for you. You shouldn't be doing this. I'm worried about you. Oftentimes these claims do stem from an employer who's truly looking out for the employee. But the employee is saying, no, I'm fine. I'm fine. I'm fine. I'm fine. And then lo and behold, something happens down the road. The employee's terminated, demoted, whatever. And the employee says, you remember all those comments you made when suggesting that you didn't think I could do my job because of this cancer or whatever the physical or mental impairment was. Says it's pretty clear that you fired me or demoted me because you didn't think I could do my job. And so you regarded me as being disabled. So that's a claim that's available to employees as well under the ADA. Transitioning to Michigan state law, Michigan has a couple of statutes. One is the Elliott-Larsen Civil Rights Act, which is equivalent to Title VII, meaning it prohibits discrimination based on race, gender, religion, national origin, so on and so forth. The two primary distinctions under Michigan law, however, is that Michigan, the Elliott-Larsen Civil Rights Act also includes height and weight as protected characteristics, meaning that you can't discriminate against someone based on their height or their weight. And it also covers individuals of any age. So recall that the ADEA, you have to be 40 years old or older. That's not the case under Michigan law. Michigan also has the Persons with Disabilities Civil Rights Act, which is equivalent to the ADA. The general prohibition against discrimination is very similar under those two statutes. Recall that under federal law, you either had to have 15 or 20 employees to be covered. That's not the case under Michigan law. Michigan law applies to any employer with one or more employees, which means it's going to cover any employer. And unlike under the federal statutes where the employee first has to file an administrative charge and that charge has to be filed within 180 or 300 days, that's not the case in Michigan. The employee does not have to file an administrative charge before bringing a lawsuit under the Elliott-Larsen Civil Rights Act or the Persons with Disabilities Civil Rights Act. And there is a 3-year statute of limitations. So it's a much longer period of time. It's much easier to file. So even if the employee misses the federal filing deadlines, at least in Michigan, there's still ample time to file under the state law. And the remedies are largely the same, so it really doesn't change much. So that's the background when it comes to the laws that protect against discrimination and prohibit that type of behavior. So what has to be proven by the employee in order to prove a valid claim of discrimination, and what do employers have to do to defend against those claims? Before we talk about that, I just want to be clear that discrimination, all the forms of discrimination that we've talked about, apply essentially from the beginning or even before the employment relationship, meaning in the application process, the interview process, the hiring process, all the way through termination. The one distinction that you should be aware of with discrimination claims is they require a materially adverse employment action, meaning that unlike retaliation claims, which the standard is a little bit softer for proving claims of retaliation, in the context of discrimination, the employee has to prove that he or she suffered a materially or adverse employment action, meaning they didn't get hired, they didn't receive the promotion, they were demoted, they were suspended without pay, they were terminated. Those are essentially what you see on the screen. But the point here is that it covers everything in the employment relationship. And as I said, even before the employment relationship. So you always have to be cognizant of the ability of an individual to bring a claim as soon as they enter as a potential candidate for employment. Essentially, regardless of the type of discrimination, meaning whether it's age or sex or gender or disability or religion, what the employee has to prove is that his or her protected characteristic, which is again, the gender, the race, the age, was a motivating factor in the challenged employment decision. And there are a number of ways that employees can go about proving that, but there are essentially two different mechanisms. One is through direct evidence, and one is called disparate treatment. And we'll talk about the burden shifting approach that applies in a disparate treatment claim. But let's start with direct evidence. Direct evidence is evidence that, if believed, establishes that discriminatory animus was a motivating factor in the challenged employment action. And this is essentially a situation where the employee can point to comments that were made typically by the decision maker. So the person who made the decision not to hire, the person who made the decision to demote, the person who made the decision to terminate, has made some type of comment, which, if true, would suggest that that person was motivated by discriminatory animus when he or she made the decision not to hire that person or fire that person. And a couple of examples that I provided to you are on the screen. So in the context of an age discrimination claim where, let's say, the employee's terminated, if prior to the termination, the employee's supervisor said, "Hey, you're too old for this job," that would be the type of evidence that would allow an individual to file a lawsuit and get straight to a jury. Those types of comments, the other example, women don't belong in the workplace, those type of comments are almost always going to be sufficient to get an employee past the dismissal phase of the case and directly to a jury. And so when you're dealing with direct evidence, there's not much the employer can do to successfully defend those types of claims, other than to just deny that the comment was made and hope that the jury believes the employer over the employee. Disparate treatment is the other type of discrimination when we're talking about intentional claims of discrimination. We'll talk about what I'll call unintentional claims of discrimination in a moment here. But essentially, these types of claims follow a three-step process. And what the first process is where the employee establishes what's called a prima facie case of discrimination. And the first three factors are almost always going to be the same. The employee or the applicant has to show that he or she's in a protected class. We're all in multiple protected classes, so that's never the problem. The individual was qualified for the position, and that usually means that the individual just simply met the minimum basic qualifications for the position, not that he or she was performing to the level required, but that he or she met the basic requirements for the position. There was some type of materially adverse employment action, which we talked about: demotion, suspension without pay, termination, things of that nature. And then the fourth prong can vary depending on the nature of the claim. So if it's a failure to promote claim, it might be a little bit different than a termination. But essentially what the employee is attempting to show with the fourth prong is that they were treated different, or that he or she was treated differently than a similarly situated employee outside the protected class, or introducing some other type of evidence of discriminatory animus, which we'll talk about here in a moment. If the employee can establish a prima facie case, then the employer has to articulate a legitimate non-discriminatory reason for the challenged adverse employment action. And in layman's terms, what that means is the employer has to say, no, we didn't terminate Dave because of his national origin. We terminated him because he was a terrible employee. That's all the employer has to do at that stage. If the employer can articulate a legitimate non-discriminatory reason, then the employee, here we go, has to show that the stated reason is a pretext for discrimination. And essentially what that means is that the employee has to demonstrate that the reason the employer has articulated is false. It's not true. It's a lie. It's a pretext. And there are three different ways that the courts have kind of looked at how you can establish pretext. And you can see here that the employer's reason has no basis in fact. It's not the reason that actually motivated the decision. The reason was insufficient to justify the decision. Those are all different ways of basically saying the same thing, which is that the employer said I was fired because of X, but the evidence shows that I was fired because of my gender or because of my race or something like that. So it's really the employee casting doubt on the employer's stated reason for the decision. And typically, the way the employee does that is by focusing on how he or she was treated in comparison to a similarly situated employee. Some of you may be familiar with that terminology. It's a term of art in the legal world. And essentially what that means is, let's say in the context of a termination, I was terminated for X. I can prove a claim of discrimination by showing that someone outside of my protected class engaged in the same type of behavior that I was accused of engaging in, or that I actually did engage in, but that person did not get terminated. That person either faced lesser discipline or wasn't disciplined at all. And therefore, because that person engaged in the same or similar behavior as me, and wasn't treated as harshly as I was, that is evidence that I was discriminated against. So you're usually looking at the same or similar conduct. You're typically looking at the same manager or supervisor, and you're looking at the circumstances to see if the circumstances are the same or different. If they're different, then the employee's not similarly situated. If they're the same or similar and it involves the same decision maker, then differential treatment can be used to show pretext. And in fact, in my experience, that's the most typical way. The other way that the employees can show pretext is through this discriminatory animus, which would be comments that maybe don't rise to the level of direct evidence, but they're comments that may suggest that the person harbors some type of animus against employees in those positions. Or it could be statistical evidence. It could be, this is the only female on the plant floor, and female employees have applied multiple times and they never get hired. So it's kind of circumstantial evidence to show that the employer may have some type of animus against employees in that particular class. So if the employee is successful in demonstrating pretext, then it means that either the judge or the jury does not buy the employer's legitimate non-discriminatory reason, and therefore the employee can prove that he or she was discriminated against. So those are the it's kind of an overview of what I'll call intentional discrimination. There's also a type of claim that is referred to as a disparate impact claim. It's much, much, much less prevalent than the disparate treatment claims. A disparate impact claim, and I'll just mention it for purposes of this presentation, but I'm not going to spend too much time on it, is just where an employer has a facially neutral practice or policy, but that practice or policy has the impact of discriminating against a group or class of employees. And the most common example that I can think of for you is where the employer has a facially neutral policy that says that in order to work in this particular job, you must be able to speak English proficiently. And in a particular job, a production job, a farming job, or different, type of manual labor jobs, that may not be the case. So if the employee can demonstrate that this facially neutral policy of you must be able to speak English proficiently is really not a requirement for the job, but it's really designed to prevent certain classes of individuals from being employed, that would be a disparate impact case, and the employee could prevail on the claim that way. Again, those claims are not very prevalent. That's really not what we're here to talk about today, but I thought I'd mention it because that is a form of discrimination. So if you do, I guess the lesson to take away from this is if you do have particularly hiring practices and you have certain requirements, you should make sure that those requirements are in fact legitimate criteria for the job so that you don't face, this type of a claim. So let's talk about what an employer has to do to prevent the claim of discrimination from being successful. Keeping in mind that you could do everything right and the employee could still file a lawsuit. So there's, other than paying an employee a severance in exchange for a release of all claims, there's nothing you can do to prevent the lawsuit or the charge of discrimination. So what you have to do is put yourself in the best position to successfully defend the claim of discrimination. So we're going to talk about focus on two different areas here. One is employee discipline and how to document that. And then we're going to talk about the 6 rules of a discharge, because those rules will essentially apply to any type of adverse employment action. And if you follow those 6 rules, and if you've followed these steps for employee discipline, and if you do the right type of documenting, then you should be in a good shape to successfully defend a claim. So let's start with employee discipline. I like to say that employees are at will with an asterisk, meaning that, yes, it's true that an at-will employee can be terminated at any time, and for any reason or no reason at all, and with or without notice. That's the hallmark of at-will employment. I can fire you at any time and you can quit at any time. But the reason I say that it's with an asterisk is because, as we've seen, there are numerous statutes, federal and state, that employees can sue under to claim that the termination was not justified, that it was discriminatory. And so while you can terminate for any or no reason, you should not terminate for any or no reason. You should treat the employee as if he or she is a just cause employee, meaning that in the context of just cause employment, I have to have a justifiable reason for your termination, and I have to prove that the behavior that I'm claiming you engaged in, you did actually engage in. If you approach employment decisions with this at will, with an asterisk perspective, or as if the employee is a just cause employee, that will cause you or force you to go through the proper steps to ensure as best you can that in the event the employee does file a lawsuit, you're in the best position possible to defend, because you've taken the steps necessary to show that no, it was not discriminatory, it was legitimate, and here's why, and here's how we can show it was legitimate. And we'll talk about this more in the context of the 6 rules of discharge, but this kind of sets the tone for everything that we're about to talk about. When it comes to employee discipline, and this would include termination, of course, the best way to ensure that your discipline is going to withstand scrutiny, whether it be from a court, a jury, or the EEOC or state equivalent, is to look at these factors. 1, do I have written policies? Written policies by far are the best way to go. So if you have a handbook, you want to make sure it has standards of conduct or rules of conduct in it. So you want something that sets forth what your expectations are as an employer and what the consequences are going to be if the employee fails to adhere to those policies. That's why I love standards of conduct. And these can be actually very helpful for you, just as an aside, in the context of defending unemployment claims. The unemployment agencies love when there's a written policy and the policy says that if you violate this policy, you will be subject to discipline up to including termination. So we'd like to start from the standpoint of having a written policy that's addressing the specific issue at hand. If you don't have a written policy, it doesn't mean that you can't move forward with the discipline or the termination. It just means that it might make it more difficult to successfully defend, because the employee can say, well, there was no policy on that. My supervisor made it up, or HR made it up, or something to that effect. The second one should be obvious, but no one understand the policy. Make sure that if you're going to discipline an employee under a policy, that your understanding of the policy is consistent with everyone else's policy, the way everyone else is interpreting that under that particular language under the policy. And that's typically where the manager and HR are working together, which should always be the case, quite frankly, to make sure that, again, we're putting ourselves in the best position. And one of the ways we can put ourselves in the best position is to gather all the facts, make sure that we have all of our ducks in a row. And that typically includes talking to the employee, depending on the nature of the discipline, to make sure we've considered all angles, we've got all the facts, and now we're ready to decide what to do. And that gets us to the fourth bullet point, is to uniformly enforce your policies, meaning that you're going to be consistent with the manner and level of discipline that you're issuing to that employee in that particular example. Because as we saw earlier, if you're treating employees who are similarly situated differently, meaning that in one situation, the employee violated the attendance policy but wasn't terminated, and in another situation, the employee violated the attendance policy and was terminated, if those employees are in different protected classes, that can give rise to a successful claim of discrimination, right? And then realize, last but not least, that every decision that you make creates a precedent for future decisions. So I always say, don't base your employment decisions on your best employee, because you'll tend to let that employee off the hook, and you're not going to want to let other employees off the hook for that same behavior. And don't base your decisions off your worst employee, because you're going to tend to want to discipline that employee to get rid of them. But then when a good employee engages in the same type of behavior in the future, now you're stuck with this precedent. So you want to try to create precedents that are based on solid decision-making, which will usually be the case if you follow the full 4 bullet points before that. Documentation is by far the most, other than the decision-making process itself, which we just kind of talked about, and making sure that you have written policies and you're implementing them in a fair and uniform fashion after you gathered the facts. If you're doing all that, then by far the most important, or the best way, if you will, to prevent a successful claim of discrimination is to have documentation. That's why I wrote here, document, document, document. That doesn't mean pad the file, which is something that you've probably heard before, meaning that we're documenting just to document. It means that if we're going to take some type of disciplinary action or some other type of adverse employment action that could be subject to challenge, we want to have documentation stating why we're taking that particular action. It's the best evidence in the context of defending claims. And in my experience, having done this for over 20 years, defending employers, I can tell you that documentation will carry the day if everything else seems to line up. So it's the best evidence. It preserves memories, because you might not be here. You know, as I said, the statute of limitations is 3 years under Michigan law. You might not be here 3 years from now. So it's helpful for your successor to understand why the decision was made. It can put us in a position to win the lawsuit as opposed to lose it. And of course, from a practical standpoint, if you've documented appropriately, then you don't have to delay decisions due to a lack of documentation. You can move forward with the termination decision because you've taken the steps. You've given the employee the corrective action. You've told the employee in writing what needs to be done. Employee's not doing it. Now we have a track record and we can move forward with the termination if that's where we want to go. So there are practical reasons beyond just successfully defending lawsuits that strongly favor documenting performance issues. What are some tips for how to document? Anytime that you're documenting disciplinary action, it should be very clear from a date perspective when it occurred, what the specific behavior that led to the discipline was, to the extent that you have a written rule, what the rule was, and then what are the future consequences. So judges and juries like to see that the employee was made aware of the rule, the employee violated the rule, the employee was told what he or she had to do to improve, and if they didn't improve, what is the consequence? That's what will usually result in a successful defense of a lawsuit when it comes to discipline or termination. And so all of that should be set forth in the disciplinary write-up. What policy did you violate? How did you violate it? What do you need to do to improve, and what's going to happen if you don't improve? If you're dealing with a situation of misconduct where it's not, black and white, crystal clear that the employee engaged in a particular behavior, then it might behoove you to get written statements from other employees and include those in your investigation file if that's something you're doing. If you are documenting and taking notes as part of the investigation, this might sound obvious, but you'd be surprised how many times I get a file where I don't know who wrote the note and I don't know when the note was drafted. Always make sure that your notes have the date on them and that it's very clear that you drafted them. Or in the case of an employee statement, make sure that the employee dates the note and signs the note so we know exactly when the employee wrote it and who wrote it. Obviously, the ideal here is to have documentation contemporaneous with the incident that we're looking at. We don't want to kick the can down the road and then, discipline for something that's stale, because when you tend to discipline for events that are stale, that can give rise to claims of a successful claim of discrimination, because the employee can and will argue, well, if it was really that big of a deal, they would have disciplined me at the time and they waited. And so I think this is just a pretext for discrimination. They discriminated against me because of my race or my gender or whatever it is. So that documentation should be timely. And then finally, it's always helpful to write as if you're writing for a third party. Now, in the context of a disciplinary write-up, that might not be as important, because those, to the extent you have corrective action forms or disciplinary forms, those forms tend to be set up in such a way where it's easy to craft. What I'm talking about in this context is be careful with your email. Email can make or break a case when it comes to successfully defending a claim of discrimination. When you are writing internal emails, unless those emails are to your outside counsel, which is someone like me, or to the extent you have in-house counsel, those emails are subject to discovery. Meaning that if the employee files a lawsuit and says, I want all of the emails relating to me that were sent to or by HR, those are all discoverable. And unfortunately, I've seen a number of cases where employers, the employer, the manager, the HR supervisor, whoever it is, very loose in email and are making comments in email that they would never make, I shouldn't say would never make verbally, but that just don't look good or they don't read well. So if you're writing something in the context of an employee, write it as if a third party is going to be looking over your shoulder. And is there anything about what I'm saying or how I'm saying it that's going to be problematic down the road? And of course, that would be true of any disciplinary write-up that you utilize. Write it so that it's very clear anyone reading this understands what's the reason for the discipline, what needs to be done to improve, what's the consequence if you fail to improve. What types of discipline should be documented? If you've coached or counseled an employee, so you've gone, usually when in these performance situations, you start with just a discussion. Hey, you know what, Dave, I really don't think you did the best job here, and here's what I'd like you to do. Do you need to document that? You could put that in a file and document it. Do you need to document it? Probably not. Where you want to start to document is when you start to believe you really have a performance issue brewing here, and a performance issue that could potentially result in disciplinary action or termination. So if that informal discussion is starting to transition from coaching to counseling, in that case, you probably want to take a note, put it in your file, let it sit there. Hopefully you don't have to revisit it. But if you see that this behavior is starting to occur again, okay, now I've got a note that shows I counseled or coached Dave about this on such and such a date. We're transitioning into more formal discipline. We're definitely going to document that, as I've indicated earlier. And of course, any termination. So the key here is, as you're starting to transition from a heads up type of conversation about an issue to, I think I might be going down the track of discipline or disciplinary action, that's when you're going to want to start documenting everything. Do you have to share the documentation with the employee? If you're taking a note, like I mentioned, for counseling or coaching for your file, then no, you don't need to share that note with the employee, and I wouldn't expect you to. But if you're formally disciplining the employee, then clearly you do, because as we said before, judges and juries like, hey, what was the issue? Did you give the employee notice? Did you tell the employee what they have to do to improve? All the above, right? And what are the consequences? So if you're formally disciplining, then yes, you're going to give the employee the document. You're going to ask the employee to sign acknowledgement of receipt of the document. It goes into the file. Coaching, counseling, probably not. That's more of just, if you're the supervisor, you go to HR and say, hey, I think we need to discipline Dave. Well, have you talked to Dave? Yeah, I have. And in fact, I have notes of when I talked to him. They're in my file. Okay, now we're in good shape to move forward, right? So those are coaching, counseling notes are really for your file to show that you've been doing something. When it transitions to formal disciplinary action, performance improvement plan, last chance agreement, terminations, those are when you're going to want to share it with the employee. So let's end with, well, there's one slide after this, but let's talk about the 6 rules of discharge. This really gets to what I was talking about before with the at will with an asterisk. If you can follow or say that you have followed these 6 rules of discharge, or you can even call them 6 rules of discipline, then you will be in a very good position to successfully defend a claim of discrimination, at least to the extent that that claim arises from a termination or a suspension or some type of disciplinary action. So what's the first rule? Did the employee know of the rule? And this gets back to what I said earlier. Do you have a published policy on this? Do you have a handbook? Do you have a manual? Do you have a collective bargaining agreement? Where is the rule coming from that you claim the employee violated? Hopefully it's a written policy. As I mentioned before, that will go a long way in helping you to successfully defend the claim. Ideally, to the extent you have written policies by virtue of a handbook or policy manual, you'll have a signed acknowledgement from the employee that he or she received the handbook, the policy manual, whatever it is. In addition to that, hopefully, or if you don't have a written policy, then at the very least, maybe you've got something where you've engaged in a prior counseling of the employee and the employee has signed it. So maybe it's like a first written, or sometimes they call it a written verbal warning or something if you're doing progressive discipline. That will establish that the employee knew the rule, understood the expectation, even if you don't have a handbook or a policy manual. So the first question is, did the employee know of the rule? How are we going to show that the employee knew of that rule? And this is how we're going to show it. Second rule, or second question, was there a fair investigation before the discharge? And this goes back to what I said earlier about, do we have all of the facts? Sometimes clients who I've dealt with, depending on the situation, will talk to, let's say it's in the context of a harassment claim or some type of situation like that, where an employee comes forward and lodges a complaint. They'll talk to the witnesses, the complaining party, the witnesses, other people aware, but there's some reluctance sometimes to talk to the employee, him or herself. And I always encourage my clients to talk to the person who is alleged to be the wrongdoer. Why do you do that? Well, one, you want to get the employee side of the story. It's possible the employee might tell you something that changes your mind about whether you think he or she should be terminated or disciplined. And even if it doesn't change your mind, it's much better to have a sit down with the employee while they're employed, and you get their real-time story without any opportunity to react to it and concoct a story down the road, than it is to wait, make the termination decision, give the employee ample opportunity, again, up to 3 years under Michigan law, to come up with a viable explanation for that behavior. and then they file a lawsuit and they claim that you're wrong or you didn't have all the facts, and you're in a deposition, and the employee's attorney says, well, you know, why didn't you talk to him? If you talked to him, would this have changed your mind? So getting the employees real-time chance to respond to the allegations is always helpful, because it either confirms your decision to move forward, tells you, oh, maybe we don't want to move forward, and it really boxes the employee into the story such that they can't really credibly come up with another version of the facts 6 months, a year, 2 years from now. So it serves many purposes. And you want to make sure, you know, just from a practical perspective, that you're doing the right thing. And so conducting a fair investigation to make sure that the employee did in fact engage in the conduct that you believe they engaged in before you move forward is always a good idea. Number 3, is there an objective basis for believing that the employee violated the rule? So are the issues documented? What is our basis for claiming that the employee violated the rule? What are we going to point to if we get sued to say, yeah, Dave did violate that rule? That could be the witness statements. That could be video. That could be, if it's a performance issue in the context of, you know, let's say like a production employee is not meeting standards. Do we have evidence to show that the employee was below the required output for the day? Attendance records. What is it that we're going to look to support the fact that this employee did in fact engage in the behavior that we claim he or she engaged in? And again, that's oftentimes your documentation right there. Number 4, and we've talked about this a couple times now, has the rule been uniformly enforced? This is going to be your similarly situated analysis. And part of this is you're going to look at, do we have a precedent? If so, what have we done? If you have a precedent, then you're, in most circumstances, you're going to be in good shape if you follow that precedent. If you have a precedent and you deviate from it, you have to have a very good reason for why you're doing that, because otherwise the employee is going to say, hey, Dave did that same thing and he wasn't fired. If you don't have a precedent, then as we talked about before, create a precedent that you can live with down the road. So look at that behavior objectively and say, okay, if any one of our employees violates this rule again, this is how we're going to treat this, as opposed to, again, looking at it in the context of your best or worst employee. But in this circumstance, we have a situation where we know we want to discipline the employee, or we want to terminate that employee. Now we have to look to see, do we have a precedent? And if we do, then we should stick to it unless there's a legitimate reason to deviate. And if we're sticking to our precedent, then we're going to be in very good position to successfully defend that lawsuit. Is the discipline reasonable? This really speaks to a fairness issue. Excuse me. And as I mentioned before, you know, successfully defending these lawsuits is as much about the smell test as it is anything else. A judge or jury in almost any circumstance can find discrimination if it wants to. A judge or jury in almost any circumstance can find that there wasn't discrimination. It almost always comes down to the smell test. So that's what we're trying to determine here. Does this discipline fit the smell test? And one of the things you have to look at is the discipline reasonable? How long has the employee been around for? How clean or unclean is their personnel file? Have they been sweet? Have they had a great career and we're firing them after 30 years for just a trivial offense? Or is this someone who's been around for a couple of years and their personnel files littered with performance issues, attendance issues, so on and so forth? That's what we're going to look at. Will the employee be surprised? An employee should never be surprised that they're being terminated when it comes to performance. If the employee engaged in harassment or theft or violence in the workplace, okay, that's fine, because no, those are one-off incidents, which even in those circumstances, the employee shouldn't be surprised. They should expect to be terminated for engaging in that behavior. But when it comes to performance-based discipline, the employee should never be surprised. We should have a track record of documenting of performance improvement plans, of last chance agreements, those types of things. If that is in place, then it's going to be reasonable to move forward. The employee shouldn't be surprised. How egregious is the violation? How long ago did the conduct occur? These are kind of really what you would look at in the context of progressive discipline. So you don't have to follow progressive discipline absent some contractual agreement to do so. Usually that's in the context of collective bargaining. But progressive discipline is not a bad way to think about things, where you have an initial warning to the employee. Then you have a follow-up and say, okay, you're still not doing what I need you to do. Here's what I need you to do, and here's what's going to happen. Okay, I told the employee again, didn't improve, termination, right? So that's what we're kind of looking at. Does the punishment fit the crime is really what this slide is all about. And if you can say, yes, the punishment fits the crime, then you're going to be in good position. And finally, last but not least, would the employee have been discharged or disciplined even if he or she was not female, a minority, disabled, 65 years old, Muslim, whatever that question, whatever that protected characteristic is, you want to insert that into your thought-making process. And if you can say yes, and that's typically going to be answered yes, because you have a written policy, you're uniformly enforcing it, you've gathered all your facts, you're in good shape. Another way to think about this is if the employee claims that he or she was being terminated for discriminatory reasons, would I be in a good position to say, no, you weren't, and here's why? And that goes back to the other 5 steps that we talked about. So if you can follow those 6 steps for disciplines or discharges, you're going to be in a very good position to successfully defend lawsuits claiming discrimination. The last thing I'll touch upon here before we're done is in the context of failure to hire, failure to promote claims. So you're typically going to see discrimination claims stemming from disciplines, discharges, those types of things, or you didn't hire me because I'm female. I didn't get the promotion because I'm a minority. I didn't get the promotion because I was too old, those types of things. The key to defending lawsuits in that context is to make sure that you follow each of these steps. 1, are there clear criteria? What are we looking for when we're hiring people into this position? What are the criteria for the promotion? And then 2, what process are we using? Did we post it? Or did we just give it to someone? And if we just gave it to someone, why did we just give it to someone? Why didn't we consider others? Did we determine whether there were other people who may have wanted that promotion? And if so, why didn't we consider that person? So what was the process? Was it open? Was it fair? If you do have an open and fair process, then document your rationale for the decision. Why did you pick Tammy instead of Dave? Why did Amy not have the qualifications to be hired? Why was Dave, not qualified for the position? You want to document that. And then, of course, to the extent possible, you have an objective review of the decision. So it's often helpful in these scenarios when you're hiring and when you're promoting is to have a second set of eyes. Hey, this is my thought process. This is what I'm doing. This is why I want to bring this person in. This is why I think she should be promoted and not these folks. So what are your criteria? Was it open and fair? What is the rationale? And have you documented it? And then could you object? Is there an objective basis for your decision to pick Dave instead of Tammy, or Amy instead of Tammy, or whatever the case is? So if you have followed that general process when hiring and promoting, you should be in good shape. So that gets us to 10:58. So we got a couple of minutes to spare. I don't think, Amy, I don't think I saw any questions here. So,
No
okay.
questions.
Okay.
Anybody have any?
So before I turn it back over to you, Amy, I'll just close with my contact information here. So if you do have any follow-ups that you thought about after the fact, you can feel free to either reach out to the chamber and the chamber will get to me, or you have my direct dial and email. So I will thank you for your time and attention today and turn it back over to Amy.
Hi, everybody. Dave, thank you very much for the very informative session. I found it to be very, very interesting. And thanks to all of you too for participating today. The handout, the survey, and the certificate of participation are now available on the webinar registration site. The recording will be available relatively soon as well. We have a lot of exciting upcoming in-person trainings and more webinars. So if you're interested, we encourage you to go to webinars.mychamber.com. And also, just please note that this is copyrighted by the Michigan Chamber of Commerce and all rights are reserved. So with that, I'd like to thank all of you again and have a wonderful day.
Thanks.